We'll move on to our next order of business. Number 3, the update on the implementation of Act Number 636 of the 2018 regular session relative to registration and voting by a person convicted of a felony. And we've got Secretary Ardouin remaining at the table to give us an update on the process.
Yes, sir. Thank you, Mr. Chairman and members. We had a very fruitful meeting with the Department of Corrections a week ago today, and we are in the process of finalizing the form that we have asked to be the certifying document to the registrars from the Department of Corrections for any individual who meets the new criteria to move forward. I would like to say this. I think initially when we were attempting to figure out how to implement this new process, I guess we were trying to make it more complicated than it actually is. Because of the way that the legislation was drafted, I think there's some debate as to whether it was properly drafted or poorly drafted, but it did not significantly or substantively amend any of the processes that we are required to follow and that the registrars are required to follow. So in 171 under Title 18 and 176 and 177, none of those processes and procedures were amended. So what we found ourselves with, and we will be issuing instructions later today to all of the registrars, and then I'll be offering the opportunity to have a conference call with them in order to answer any questions that they may have, is that they're still going to have to go through the normal processes. And as we see those processes, as if an individual is convicted of a felony, then that individual has to be reported to us by the Department of Corrections, as is current law. Once that occurs, we notify the registrar of those individuals in their area, and they will have to suspend those individuals and send them under 178 a 21-day challenge if there's any reason by which they should not either lose their right to vote as it being suspended, or if they meet the current criteria of Act 636 for continued voting privileges. If they do not meet that, then of course they remain suspended until such time as they do meet those new criteria. Nothing has changed in the responsibility of the individual to follow through and obtain the proper certification documents and to return those or bring those to the registrar of voters for them to either stop the suspension of their registration or to re-register or to register initially if they have not been registered for quite some time. So none of those processes have been changed. It may seem that it's archaic that we continue that process, but the fact of the matter is that's what the law says we have to do. And so we're going to continue doing that, because if we changed, we open up ourselves for any potential lawsuits. And with all the threats of suing me in my office over this one issue, we were very meticulous in how we looked at this process and went through it prior to us ever even meeting with the Department of Corrections. I feel confident in the processes that we've come forth with. The Department of Corrections, Secretary LeBlanc and I, we had a very good meeting with his staff and my staff. They appreciated the format of which we were seeking to do it. We're trying to go to one single certification form that will be certified by his office and by I believe the parole or probation officer in one of their 21 regions. And so that will be the document that the individual collects from their local probation or parole office, and then take that to the department, the registrar of voters in their parish where they wish to register to vote. I think that's as simple as I can boil it down. I have our Deputy Commissioner of Elections and my Executive Counsel here, Laney Durio, to help me answer any questions that you may have.
Thank you. And I just want to make sure that you clarify on that. prior to Act 636, if a person was convicted of a felony and their registration was suspended, it was up to them to come back to show that they were no longer under an order of imprisonment, meaning they were no longer on parole or they were no longer on probation. So that is what the procedure was prior to Act 636.
That is correct.
And with Act 636, the only thing that's going to change is to show that they will show that they're not incarcerated and that they have not been incarcerated in the previous 5 years.
That is correct.
And so, okay. All right. Thank you. Second argument. And Ms. Durio, do you have anything to add? State your name for the record and we'll go from there.
I don't have anything to add. I thought he did a great job. Lainey Durio, I'm the Deputy Commissioner of Elections.
She's paid to say I do a good job.
Okay. She's paid to say the truth too, right?
Right, absolutely.
Representative Jenkins for a question.
Yeah, a few questions. Thank you, Mr. Chairman. But let me start out with this question, Mr. Secretary. Do you feel like your office, do you feel like this state is ready to move forward with the fall elections, implementing this new law? Are we ready to get it done? Are we ready to make sure that persons who are now eligible to vote under this new law are going to be able to walk into a polling place in the fall elections and be able to vote? Are we ready?
They will have to register to vote before they walk into the polling precinct.
My question is,
Yes,
do
sir.
you feel like your office is ready to do it? I understand there's some procedures involved.
My office is ready to do it.
Okay. Now, let me ask another question. I'm just trying to get some clarifications in mind. Have we, or have your office, or has the registrar of voters, whoever the responsibility may fall upon, have we got some notification out to persons who may benefit from this new law? What I mean, some kind of written notices? Have we put anything on websites? Have we done anything to say this new law is going to be implemented? You may be qualified to vote under this new law. What steps have we taken to really notify the public on it?
None yet. We wanted to get the process by which we would work with the Department of Corrections solidified. We wanted to make certain that the information that we would be getting would continue under the current law. And we wanted to make certain that we moved from multiple versions of certification to a single form, which the law requires us to do, the new law. And so once we got that together, and we're waiting on, I think we're waiting on final approval by the Attorney General's office of the form, which it has not changed too substantively, so I don't see that taking very long. But we are prepared to send out a draft of that form to the Registrar of Voters today, along with instructions on how to proceed and to follow current law and the new law. And then, as I said, I'll be opening up next week for a phone conference with all of them around the state to answer any questions they may have or concerns they may have. But as far as I can tell at this point in time, once that's occurred, we'll be ready to start the process on March 1st, which is the effective date of this legislation.
So will there be an opportunity for some kind of notifications to go out before the fall elections?
We certainly can put the new information on our website, but again, the law only requires that the information come from the Department of Corrections to the individuals. If the individuals are reading the newspaper or seeing any of the articles or being contacted by some of the interested parties that have contacted our office, we have encouraged them to provide as much information out to their constituencies as possible. But certainly it's incumbent upon the individual to present themselves to the Department of Corrections, obtain the paperwork, and then go to the Registrar of Voters office.
Now, and on that subject, if I understand it, if a person goes in to register and vote, and they're under an order of imprisonment or have a felony conviction, aren't they flagged some kind of way by the Department of Corrections? Why can that
They're-
system also
they're actually-
kind of unflag them, so to speak?
They're flagged by our office. We receive 2 lists now. We receive a monthly list electronically from the Department of Corrections, letting us know of individuals who have been convicted of a felon. Because of current law, we are then required to flag that individual, and then the registrar of voters knows to send a letter of suspension to that individual at the address that we have them registered to vote. Then they have 21 days to present themselves to the registrar of voters with any paperwork that requires them not to be suspended. So we have to go through those steps.
Well, why can't the Department of Corrections, who initially, once you get that information, they can't give you an all clear on the person, so to speak? Say, just as this person was convicted of a felony and may be subjected to their voter registration being suspended, why can't the Department of Corrections and your office come together with some kind of all clear coming from the Department of Corrections rather than having the person go through all of these steps?
Because you all didn't amend the law to allow for that to occur. You all continued those statutes in question, which is 176 and 177 under Title 18. I'm sorry, 171, 176, and 177 under Title 18 were not substantively amended to change the process by which an individual who met the new criteria could register to vote. We are still required, when we get the notification from the Department of Corrections, to flag that individual for suspension. The registrar is still required to send a 21-day notice to that individual at their registered address, and if they do not appear within those 21 days, then their registration is suspended until such time as they provide the appropriate paperwork. If you all had amended those processes, we wouldn't have to do it, but because it was not amended, we have to go through those processes.
So there's going to have to be some legislation that would allow the Department of Corrections to give an all clear to your office on someone who now qualifies under this new law?
Well, Representative Jenkins, there is a second list that we've now begun to receive from the Department of Corrections that was required by a law passed by Representative Carter and Barbara Carpenter, excuse me.
Okay.
More Carters.
My apologies. I was watching Representative Carter fiercely writing notes, and I'm like, I'm going to have a whole bunch of questions coming up. But so we receive a second list now that provides for the individuals who may be eligible by by the criteria currently and the old criteria to meet the registration requirements. So that data is also in our system, and we will be sending that we just received that first set of data, and we will be sending that also to the registrars. So that is like a second check for them. So if an individual was on the original list, will continue on the original list until such time as their sentence is completely expunged, or they're finished with their sentence.
So it'll be ongoing.
That's the only time that they drop off of that list. So they'll be on the original list. Then the second list, if they appear on that second list, that means that they are eligible for different treatment because their sentence may be suspended, and so they're eligible to continue voting, or they may be on probation and time served allows them to continue to stay registered and participate in the system. So that'll be like our second check, but they still will have to come in with the paperwork because the processes haven't changed yet.
And that's a matter of legislation.
That is a matter of legislation.
All right, we'll look at that because it sounds somewhat, and I'm not necessarily saying your office is making it difficult. I'm sure you're trying to do what you need to do, but it sounds a little cumbersome.
Well, that's what really took us a while before we could actually get with the Department of Corrections, because I did have a meeting some weeks ago that was originally scheduled, and I asked that it be rescheduled, because what we were trying to do is we were trying to take a square peg and put it into a round hole. And what we realized was, in fact, it was an evening where I'm studying the election code at my home, and I called Laney and I said, wait a minute, they never changed the process. So in our minds, we were already beyond that portion of it, and we kept running into roadblocks internally on how to implement this. And when it's staring you in the face when you're studying it, when I realized that 171, 176, and 177 had to be changed, and they weren't, then that made the process a whole lot simpler, and that's where we went.
Okay, all right. Thank you, Mr. Chairman. That's all the questions I have at this time.
Thank you, Representative Jenkins. Representative Carter.
Thank you, Mr. Chair. Mr. Secretary of State, congratulations. I don't think we've seen each other since your election.
We haven't. Thank you very much.
And you've been in this role, at least supporting this role, for quite some time. So I know from our personal meetings, you know these things well. So we've been talking about the restoration of voting rights for felons.
Correct.
Who exactly do those rights are restored? Whose voting rights are now restored?
Anyone who has who has not been incarcerated for the at least 5 years are now eligible to register and vote.
And how many people do we think that may be in Louisiana?
I'm going to defer to the Department of Corrections for that.
The last, I believe around.
Natalie, could you
give me your name again? I'm sorry.
Natalie Laborde, Department
Hi,
of Correction.
I'm Gary Carter, Natalie.
Thank you. Nice to meet you. Approximately, I would say 36,000 is the most recent number I have, or updated number from our department, and that would include those on probation who have never been incarcerated pursuant to that order of imprisonment, and then those on parole who have gone 5 years without being incarcerated pursuant to that order.
And so for these 36,000 individuals to now vote, these felons to now be able to vote in Louisiana, they have to, the process you're planning is for them to complete some certificate, some form?
We are asking that they go to the Department of Corrections and obtain a certification form.
When you say go to, do you mean physically go to the Department of Corrections, or you mean go to like their website?
That's up to how the Department of Corrections wants to implement it.
That's up to someone else other than, okay.
I can speak to that issue. So I agree with everything Secretary Ardwin said about the processes delineated in the election code regarding the reporting requirements, and then also with this new law, how a person would present documentation to the Secretary of State that they meet this criteria. So we have agreed upon the content of the form, something that we will generate via our office, and a person would get this form filled out from their probation officer. So they are going to be able to pull the person's file, ensure that they meet this criteria, and then give them an official document that they can present.
So if I'm understanding the process, the Department of Correction is going to contact the probation and parole officers and say, here are the forms that these individuals need to complete in order to have their voting rights restored?
I'll just walk through how.
Yeah, walk through it. So
yeah.
I want to be clear so everyone knows the
Absolutely,
process.
yeah.
And listen, thank you. This is huge for Louisiana. This is great. I just want to make certain that we make the process as simple.
And,
Absolutely. Absolutely right. And I want to make this easy. We're talking about a fundamental right, a constitutional right to vote that's being restored. And so I want those people who now rights are restored to make certain that that process is clear and as easy and simple as possible. And thank you, Mr. Secretary, for working on this. I was jotting down feverishly the process, and one of the concerns I had was the delays in the process, right? So if someone wants to register, if there's an election coming up in March or October this fall, how long of a process is going to take for that person to go through filling out whatever this certifying form is, bringing it to the appropriate people, having them do whatever checks and balances they need, but I need that person to be able to quickly vote in an election.
Well, Representative Carter, the form is going to be generated at the Department of Corrections. So
yes, I understand that. And one of the things I wrote down was a copy of this form is going to be released from the Department of Corrections to the Secretary of State today, or a draft of it or something like that.
We've been communicating back and forth. Natalie sent us a new draft yesterday that our office has already approved. We're fine with some of the new language. So if I don't hear from the Attorney General's office today, I'm still going to send that draft out to the registrars in order to expedite the instructions and what the form generally looks like.
And I'm asking because this committee does have oversight that a copy of that letter be produced to the members of this committee, the draft of it, so we can look at that form to see whether or not we have any suggestions, we have any questions. And I don't want to get the form where it's already finalized and a time for comment and input is already passed. I don't have a copy of. Can I have that copy?
There should be enough copies here for the committee members.
Excellent. That's good. That's good. So please keep us posted. We want to be an asset to help make sure, one, that these forms are available to everyone, that this process is as simple as possible. And so what's the next part of the process? So after there's an agreement to a form.
So I'll walk it through the process as I understand it for a person who would like to register or reinstate. So if
Okay.
you're I, Natalie, would like to register, and I'm also under an order of imprisonment. I know there may be some restrictions there.
Yes.
I would apply to the department. Please jump in. I would apply for registration to the Secretary of State. I would also have to check that I'm currently under an order of imprisonment. Secretary of State requires secondary documentation from the Department of Corrections, or that person submits secondary documentation.
What kind of secondary? Some certificate. This is
Certifying
the
that-
certificate
certifying
from.
that you meet the criteria of this new law that creates the exception, has not been incarcerated pursuant to that order of imprisonment for the
Got
last
it.
5 years.
Okay.
I would request, Natalie, from my probation and parole officer at the district, can you please generate, I believe I'm eligible under this, can you please generate this form for me? So I wouldn't have to bring a form. We will be able to just generate it through our computer system so that we have a digital record in the person's file that their probation officer.
And when the probation and parole officer receives it, I'm always concerned that we don't have enough probation and parole officers. And so is that any concerns that there'll be in a backlog or delayed with when those individuals actually receive, those probation and parole officers receive the certificate?
I actually
I hate to
have-
be in the weeds
No,
on it,
no,
but I want to make sure I
completely.
understand the process.
Actually, I have our director of probation and
Certainly.
parole here, P. Freeman, who could speak to that part of it.
Yes.
But moving forward, and I'll get him to.
He'd step right out.
That's why we
Oh.
can tell you when he comes
So
back
assuming
in.
there's no backlog, they generate the form. It's official. It's from Department of Corrections certifying you meet these requirements. That person then takes that form and submits it with their application to the Secretary of State, who then makes the determination, yes, you can register.
And and when you say someone from your office makes the determination, like someone has to physically like read it and make the certification, or is it, we were talking earlier about computers doing our work for us? Is it going to just be a computer just, there it
No,
is?
the process was not changed, so the individual has to appear to the registrar with the form.
In
you know,
person?
In person.
In person at the registrar's office in Baton Rouge?
No, sir. In any of the 64
Oh, okay.
registers.
Not your office.
My particular office, but the registrars.
Which, to clarify, Representative Carter, that is the same process right now for someone who is under this current law. If they had lost their voting rights and they completed their term, their order of imprisonment, to restore those, they would go in person, as I understand, to restore
That is correct.
those.
Is there a way for us to automate this process? Because one of my concerns here is we've worked on it, Mr. Secretary. How do we make it easier for people to register to vote?
Well,
For instance,
let
we
me
passed.
shortchange you for a second.
Yeah.
They can if they have a Louisiana ID
With the audit, with that
with
three
the audit code. They can register online, but they are still going to have to appear to the registrar with their paperwork.
and what I'm trying,
they will be in
and
the
part of
queue.
is so we worked on legislation together
They will
that
be in the queue, just as we worked on that previous legislation.
Yeah.
They will be in the queue if they register at 12:01 on March 1st
okay.
online, utilizing the Louisiana ID with the audit code.
I'm with you.
Then they will be in the queue.
Okay.
But the registrar is going to receive that and say, "Oh, I'm sorry, I'm going to have to send you a 21-day challenge." So they're going to send that challenge out, but it does not prevent the individual, if they already have the form, to show up in the office at 8:30 in the morning and say, I registered online at 12:01 a.m. here's my paperwork.
Here's my concern. My concern is having, for someone whose voting rights have been restored, requiring them to show up in person at a register of voters office, at a government office, in order to have their voting rights restored, especially when we're moving so much in terms of technology into being able. I have a Louisiana copy of my driver's license. I can register to vote with apps that we use from the Secretary of State, where you can do it online. But for one of these felons, and we want to make sure that these individuals who may not even know that their voting rights have been restored, that one, like Representative Jenkins, let's make certain that these individuals know their rights have been restored. And two, let's make it as easy as possible for them to actually go out and vote. And this process of requiring them to show up in person, I'm just a little concerned with it, but I'm glad the process is moving forward. Keep me posted on it, and please, let's talk about a way to automate this, that if we can eliminate any steps. And I understand we're bound by rules and regulations, but I also know that we have enough smart people around. We can study this issue to simplify it and make it as smooth sailing as possible, because I want a nice percentage of this 36,000 people to actually vote and participate in these elections this fall. And I'm asking you and your office, the Department of Corrections, Parole Corrections, Secretary of State, the Governor's Office, all of us in our individual districts, to make certain we reach out and let people know that, hey, Louisiana has done a good thing here. Let's go get those people to vote.
Let me say this, Representative Carter, on behalf of my agency, and speaking for the registrars as well, and the Department of Corrections, if I may, we are all working very well together, and we are following the process that you all have dictated through law as efficiently and as effectively as possible. If you want it to work any faster, then you're going to have to change the law.
Got it. And so keep us posted on it. So certainly, I think they just handed us a copy. We're here to help. I'm glad we've done this, and I may be asking questions, but I want to make sure this process is clear, is clean. You talked about they're assembling a database of people whose rights are now perhaps whose rights are going to be restored to vote. And so my question is, I know the Secretary's listening. Is that list going to be disseminated to members, legislators? To who's going to receive a copy of that list? To the Department of to Secretary of State's office? What office is going to receive this information of these are those 36,000 people who can now vote?
We already have the data of who's a convicted felon, because we get that from the Department of Corrections on a monthly basis.
You have it, but do you disseminate that to the public?
I do not. I'm not even sure that I can disseminate that to the public.
So there's no way for us to say that, and this is what I'm asking for. I want to identify, hey, of this 36,000 people whose rights are restored, this is the number I have in New Orleans. This is the number I have in my particular district in the city of New Orleans, where we can say, hey, let's go grab them and tell them, knock on their doors and say, hey, I got a flyer here that tells you your rights have been restored. Here's a quick process. Let's get you up to speed. Let's make an appointment with you and your probation parole office and start working this process to streamline it, to enable us to engage our communities.
Natalie's going to speak to that, but let me say this on the outset. We have the report that we get from DOC that tells us who the felons are.
Yes.
Then we are now getting a second report that says these are the possible individuals who may have their rights restored or never suspended.
And that's the list I want to see.
But it's generated from their agency.
Okay.
So I'll clarify the components of the law we're dealing with. And as Secretary Ardway mentioned earlier, this new law, which allows for these exceptions, did not update the reporting requirements for DOC. So the lists that we are sending are not really at all relevant to this new exception. The lists that we are required to send under law are first, everyone who is under our custody.
That's the first group that we were
Probation,
talking
yes.
about. So I got that one.
Yeah,
Yeah.
the existing law.
So what about the second group?
So that first list is everyone under the current law who's disqualified.
Yes.
The second list that Representative Carpenter passed in 2018, again, really doesn't have anything to do with this new law. It's two sides of the same coin. It's those who are no longer under the custody or supervision at all.
That's right.
So the 5 years doesn't even matter for them either. It's two sides of the same coin. if a
But
third
if there's a
list-
way for us, if we had the second list, is there a way for us, if we had the second list, is there a way for us to drill down in the data and be able to say these are the individuals whose rights are now restored under this list of people? Like, for instance, I would imagine, let's say you generate the second list and it's 50,000. I know 36 of the 50 it would apply to.
everyone on the second list, essentially, arguably, their rights have been restored. They're no longer under an order of imprisonment at all. They're not
and you
DOC.
can't make that list public.
And they are required under current law, new or old, to present themselves to the registrar of voters with the proper documentation to register to vote.
I got that part. And then my next question
understand
is,
the
and then my
function
next
here.
question
Right.
is that list
I
though of
don't
those
know.
people, is that list can be made available to us so we can help identify who they are? I know you may know who they are, but you're not going to knock on their door and ask them to vote, to register to
I
vote.
can't physically do that.
I will.
I would.
And so I'm trying to get like a copy of that list.
I would defer to the Department of Corrections
Yeah.
because I would not know exactly what information should be redacted from it. So I would prefer.
Correct.
A
So that would-
redacted version, certainly. I don't want anything.
First,
Yeah.
what there is personal identifying information on there, so I'm not sure what would be considered.
Let's
public
work
and
on
not.
that because I want to see that list. I want to reach out and grab those people and knock on those doors. And we can visit offline. I want to continue to move the ball forward on this. We have elections, big elections coming up this year.
I understand. And then
Every election's big.
the third.
I'm on the ballot, sir. You are
As am
too.
I.
And as I understand, to address some of the other committee members' questions, there is no reporting requirement that was put in pursuant to this new law related to these people with the 5 years versus 5 years of who haven't been incarcerated in the 5 years pursuant to an order of imprisonment.
Yeah.
The only mechanism for making that determination on their part is a person submitting individual documentation. I do think that this body could revisit that this session,
Certainly.
and streamline it. in
And
terms
then
of a
and also, but I also want to make sure though, that I try to identify, and Kyle, we've talked about, Mr. Secretary, we've talked about this. Sorry, I'm used to first name basis.
Mike it
I'm
down.
used to us having conversations about how to identify those people in my district who aren't registered to vote, who are eligible to vote. And so having access, provided we don't want to release anything that's too personal, but I want to be able to see these are the people in the city of New Orleans or in Baton Rouge or Lafayette, like wherever, that are now eligible to vote. And certainly the ones in my district, I can go knock on those doors where I know them and say, hey, listen, your rights have been restored. Let us help you get through this process to make certain that you can vote. And as we streamline this process. So let's include me on calls, conference calls. This is important. I want to be up to date on all of this.
Absolutely.
Thank you.
And I'd like to hear from Pete Freeman with the Department of Probation and Parole. I think the Director of Probation and Parole kind of can fill in blanks if we can make room for Mr. Freeman.
Yeah.
Good morning, Mr. Chairman, committee members. My name is Pete Freeman. I'm the Director of Probation and Parole for the state of Louisiana.
Thank you for being here.
Yes, sir.
Thank you.
This is a big initiative, and we know how important it is, Representative. So we're trying to do everything we can to help.
And we want to make sure y'all have everything y'all need to make certain that we do this the right way. So when those probation and parole officers, when they receive that form, I just want to make certain that there's no delays, there's no back. And I know that you guys y'all work hard. Listen, I know your group. I've met tons of. We haven't worked together, but and we've talked in terms of criminal justice reform, whether or not they're capable of handling the workload. And what I don't want to have here is a backlog of those forms restoring rights to people. That when your probation and parole officers receive it, they immediately process that information.
Yes, sir. And that's what it's going to do. It's going to
Okay.
be on our Cajun database.
I don't know what that is,
Okay, well, it's our computer system, which is very antiquated, to say the least.
but that doesn't make me feel,
But the minute they request it, it will print the letter and say they're eligible. My officer will check eligible, and then we'll certify it with a seal, and they can bring it to the registrar's office.
They're given a copy of that letter.
Yes, sir.
Is there an electronic copy of it? What if they lose it, like a scan? Can when they fill it out, they just, we fill it out online or something like that, or have it, you have someone in your office say, we received a certified copy, and electronic record goes to the Secretary of State, and I don't have to worry about them showing up now doing two separate steps. I have to have them show up to probation and parole. Now I have to have them show up to the registrar's office. Maybe understand. Maybe the one that's required is the showing up at the registrar's office. Is there a way for perhaps this part with the probation and parole? That's one of the parts of the process that can be looked at, that can be streamlined in some sort of way. But requiring two separate personal appearances seems like a lot.
I'd just like to point out that this certification will go a long way to streamline the process, because right
And I haven't had a
now-
chance to see it. I just, hopefully I got a copy of it.
Right now, there are any number of documents that the registrars will receive, and some of them are not always easy for the registrars to interpret, to see.
I get that. I see the purpose of a form,
we'll
but
make
here's,
it much
so
easier.
someone shows up, now, let's say John Doe can now vote. So John vote, the first thing he has to do is to show up at probation and parole and have this form completed.
Yes, sir.
And signed in person by someone, right? Then they have to take that form, don't lose it, don't get it wet, don't get it destroyed, don't get it eaten by your dog, your cat, whatever, and show up in person to the registrar's office. And then those rights will be restored after a delay of some sort.
Which is the process today.
That's the process today, right? And so the process that's required by law today is the showing up at the registrar's part. Is it required by law, this first showing up in person to visit with?
Yes.
That's too many steps.
Yeah.
So let me ask you this. Is there any way for your office, when they come in and fill out this form, certify it, that you send the electronic record to, they have it? And
It's a matter of making certain that the registrar has the appropriate paperwork coming from the appropriate department and keeping that on file so that we don't have to go through this every year, because every month
We agree.
that individual is going to be on the report,
Right.
and every month
So if when-
technically they're supposed to send a 21-day challenge, but with that form in their
so there's going to be an electronic copy of this that's going to be sent from probation and parole to,
not sent but kept
When the
kept
re-
in their files.
when-
why can't we just send it?
When the registrar, excuse me, I keep saying when the registrar receives this field format and signed and certified, they will retain this for their files, and they can scan it and keep it electronic.
And my question is, when they scan it and keep it electronically, can they press a button that forward it to the registrar's office where they have it now? I understand the person may still have to show up in person, but now they have that document.
No, what I was saying was the document has to be brought to the registrar for
have
them
it
to
in hand.
retain.
By law.
Yes.
Yeah, we need to revisit the law on this. Let's get together and visit, but let's keep moving forward. Is the best way to streamline this process, and let's certainly come up with some best practices that we can look at for this coming session. That we can, I don't know, in terms of implementation, what we can do to make this even better. Okay, but thank you, thank you for y'all work on this. Thank you, Mr. Chair.
We've got a couple more questions people been waiting to ask, but Mr. Freeman, thank you for being here. But I have a question, and a lot of this stuff, probably wasn't asked, maybe, but in terms of the boots on the ground and the details, I haven't practiced criminal law in a while, but a lot of these sentences are, with the order of imprisonment was pretty clear when we defined it as purely as including, as we defined it as being on probation and or parole. But now with the additional level of saying, if you have not been incarcerated pursuant to the order of imprisonment, and I have a question. If, for example, if someone, for example, pretrial detention has served 6 months in jail, and they go ahead and plead guilty, and the judge sentences them to say 5 years suspended with 3 years of active probation, but then they say with credit for time served. I mean, my question would be, would that be considered an order of imprisonment pursuant to that conviction, incarceration pursuant to that order of imprisonment, because you're not sentencing them, but if they were ever revoked, they would be getting credit for the time that they served, and y'all would certainly calculate that. My question is going to be how are we going to interpret, especially that pretrial or pre-conviction detention?
But we're going to interpret it the way we always interpret things. We have two levels. We have the incarcerated and we have the ones under supervision. You're not incarcerated to us unless you're doing DOC time. So that's the only way we're going to be able to do it and keep it simple. It's just like if myself got arrested for a DWI, they might keep me in jail 3 days, but I don't lose my voting rights. And our opinion is they shouldn't lose their voting rights either unless they're revoked.
Or if the judge says, I'm going to sentence you to 5 years, but I'm going to suspend all but 6 months, and so that but that 6 months you've been given credit for time served because that's how long you were there, pretrial incarceration. It seems like that 6 months was pursuant to the order of imprisonment.
And that would make them ineligible.
Okay.
Because they did do DOC time and they got to be 5 years out.
But if they suspended all of the sentence,
They get to vote right away.
okay.
Shouldn't lose their, technically, like he says, the lists are going to be confusing. But technically, if you get put on probation, you should not lose your rights at all. Right now, they're on that list. So we got to clean that up to where we can take them off that list and they never lose their voting rights.
Ms. Laborde? you
Yeah,
had
Natalie
something?
Laborde, DOC. And I think first and foremost, there's a lot of hypos that relate to this situation. And I think we would all appreciate some clarification by the legislature. In terms of incarceration for Department of Corrections, as Director Freeman mentioned, we have two classifications. We have those in our database, our coding system. We have those who are classified as PRI, those are those who are serving physically in the custody of Department of Corrections in a confinement setting, and we have those who are on supervision. Some of the issues that have been raised, well, what if someone's on supervision and they received a 3-day jail sanction? For our classification purposes, that never changes from supervision to PRI because those things are legislatively created alternatives to revocation for us. So that is where the line in the sand is for us as a determination if we're being asked to make that without any clarification in the law. Your example, I understand, is a little bit different because the incarceration was prior to the actual conviction. I would have to check with our data staff to see how they are coded in our system for the credit for time served counting towards the incarceration period of their order of imprisonment. I don't know the answer to that, but still it would fall, the coding is what would matter for us in terms of making the determination of the 5 years.
And
Mr.
I know
Chairman.
you want to say one more thing, but you bring up about the a sanction. So if that guy is got a 5-year suspended sentence and has never been incarcerated pursuant to that order, and he's not doing what he's supposed to do, and there's a probation revocation rule filed against him and trying to revoke his probation, and the judge says, I'm not going to revoke his probation, but I'm going to sentence him to 6 months, or 30 days or whatever it is, and try to get his attention because we do not want to revoke, the judge does not want to revoke the probation and sentence him to that full sentence.
Correct. So those are, in your example, that's something that, probation is a little bit different because they have the judges more the authority. But for that same example with parole, if the board implemented a sanction, they would never be under our classification system. Someone like that for a jail sanction is still considered under supervision of probation and parole. They are not considered a prisoner for us, for our classification.
And Secretary Ardwine.
And I think that's where it conflicts for us, and we're asking for you all, the legislature, to provide us some clarification in the upcoming session, because there is no definition under Title 18 of incarceration, but the legislation is very clear that you could not have been incarcerated for the past 5 years. If someone is incarcerated for a weekend or 6 months, does that fall within the act, and is that a game changer for this individual and resets the clock? And I think that's where you all have to come in and answer those questions for us.
Okay, thank you. Representative Ivey, thank you for your patience.
Thank you. Got a few questions for clarification. Starting with, do you know, you have that list of all the individuals who were suspended? If we're on the suspension list where when they were
yes.
when you got the initial
second list,
felony.
yes.
So we know how many of those individuals who were already registered to vote before, correct?
If they were
Technically.
registered.
Right. So do you know approximately what percentage or ratio of individuals who, when they received their felony conviction, were no longer eligible to vote, were already registered to vote?
I'll have to get back to you on that because we just got our first list. We've been working back and forth. Just as an aside, when the state decided to combine all of IT into one department, and luckily you exempted our department from that, obviously for very specific and purposeful means. It created issues for others, and so there's been a lag time where DOC is having to been working with the Division of Administration to get that information in a way that we could receive it, and then we could decipher it. I have a meeting scheduled this afternoon with my IT staff to go over just that data and that information because they have some concerns.
Right. My assumption will be that it will be lower than average for individuals who committed these types of felonies, especially if they're younger in age, so that they may not have registered to vote already. So I would like that data because
Sure.
I think, and so now if someone was suspended, they were registered to vote and they had that suspension. If you receive the information from DOC that they are no longer under the conviction or whatever, does that suspension automatically get lifted, or do they still required to bring in the paperwork?
They're still required to bring in the paperwork.
Okay. Let's see. Does an arrest, let's say so they were arrested for a misdemeanor, judged 30 days in jail, does that reset the 5-year clock or not?
We
We're
don't
waiting.
know because there's no clarity in the law on that.
You mean we wrote a law that wasn't clear? You gotta be kidding me. Never in Louisiana. Okay. So then the follow-up question to that was, if they get a letter, let's say someone goes through this process, they get their document from DOC, and then but they don't complete the process with the registrar of voters. 6 months later, they're arrested. They still have that. Let's say for a moment we were clear, and that would reset the clock. If they had that letter, from just before the arrest, would they be able to present that same letter 6 months later, or is there some expiration date on the validity of the letter?
There's no expiration date, but they would, if they are if they are incarcerated if they are convicted of a felony different from the one that they already were convicted of, they will reappear on the monthly list that we get from the Department of Corrections. If they are incarcerated, whether it's 1 day or 10 days or 100 days, whatever it is, they're not going to show up on the list in a new format as I understand it.
Because you're not tracking any rearrest for misdemeanor, things like that. It's only felony. That's the only thing y'all are really tracking for y'all's purposes.
For DOC's reporting purposes, correct.
Okay. All right.
And that's whom we are dependent upon for our information.
All right. Now, you can register to vote online. The National Get Out, Register to Vote Day. I was at LSU, telling kids, hey, you can go online. It's really easy, all that. So that's great. And, Secretary of State's website is, for business purposes, 100% online, correct?
Correct.
Y'all are ahead of the curve, I think, from many state agencies.
Thank you.
That said, is it possible to help facilitate? I know what Representative Carter was really getting at. And again, the process is what it is legally, but to where you can register to vote when you're getting your driver's license, renewing your driver's license. That's a
Right.
box they can check. This is obviously a different circumstance, but could DOC basically at the point of them coming to get that document simultaneously submit for registration? But I mean, would the law have to be changed in order to do that?
The law would have to be changed.
Okay, but I mean that would be the simple process instead of having someone to have to go back. I mean, if they're eligible for it,
Simple
you know,
and costly. The system we use with motor vehicles is one that our agency developed and runs behind their system. So they actually go from OMV into a separate system.
I'm keenly aware of OMV's
and then
technology problems.
Then we secure it, and then we drop it down to the registrar of voters. I would imagine that would be the same type of process we would have to look. If we go to an electronic type process for this, then I would want to be able to make certain that there is a tracking number or some
Sure.
sort of tracking format so that it could not be hacked into and duplicated.
Sure.
And
Absolutely.
causes
Yeah, absolutely.
problems.
Follow up to that, if I'm sorry, I got 2 hours sleep last night, so all right. So I mean, it sounds like some things would need to change just to facilitate more timely transmission of data. Is all it really is.
And I will tell you this: if anyone who knows that they fit within this category of new registrants, then they can go through. If they have a valid Louisiana ID with the audit code, they can go through the online process. They will sit in the queue until such time as they present themselves to the registrar of voters, which will keep them in the time frame that they need if they want to exercise their right to vote in the election on the 29th of March.
Okay. One final question. When someone goes to get their driver's license renewed, are they asked? Does something pop up if they're not registered to vote? And are they asked would they like to register to vote? Or
They are every Office of Motor Vehicles or vendor of that agency is required to ask every person who sits at their desk to renew their license or get a license if they would like to register to vote.
okay, whether you're
By the National
registered.
Voter Registration Act.
Okay, and that's whether or not they are currently registered.
That is correct.
Okay, so anyone who is formerly incarcerated who goes to get a driver's license, what about an ID? Does it just driver's license, or does it also apply to state IDs?
What? Yes.
Okay, so from a notification perspective, I don't know if there's many people who are released who don't go get an ID of some sort, whether it be a driver's license or an ID, who at that point would not be notified. Well, I guess they wouldn't know that they're eligible technically, but they're asked to vote.
We are currently I'm told by staff we're currently reprinting the signs at the that go to the OMV offices for the new requirements.
Okay, so at the OMV office, it will now tell them if
Correct.
of this new law.
Correct.
Okay.
But remember, even if they register to vote,
They still have to do the process.
they still have to go through the process.
Correct, correct. But from an information, because that was one of other Representative Carter's other concerns, is letting them know. So at that point, they would be notified.
As we renew all of our normal notification, informational pamphlets, signs, wherever they're placed in public agencies, all of this information will be added to it.
Okay. And I said last question, I misspoke. With regard to the publication of such a list of to me, I would also be concerned about the right to privacy of the individual who doesn't want to be on that list, to where the whole world knows. We assume that it's a good thing that we want to get these people to vote, but they may not want to be called. We get spam calls all the time, and so from that perspective, I think it's
glad you
a
mentioned
double-edged sword.
So we're part of the Electronic Registration Information Center, which is an data exchange process between about 23, 24 states now, to make certain that people aren't double registered in various states. Part of our membership to that is that we send mailers out every couple of years to individuals that we think are not registered to vote. And if I could show you the hate mail we got back from individuals who absolutely did not want to register to vote, and they wanted to know how in the heck we got their name and address, etc.
Right.
There are people in this state who do not wish to register to vote.
Correct. And they have the right not to register to vote. And so to me, we can't assume that everyone in this category would want to be contacted. And so
Correct.
that's again, it's part of my concern is to respect their rights when they're re-entering, society. And of course, 5 years after.
And DOC works with us. We're currently updating the information with them to give to every single individual as they leave incarceration as to what their rights are. And so we're updating that information so that they will know when they leave the incarceration process when they're eligible to re-register to vote.
Sure, because if I was formerly convicted and released, and I got a knock on my door, and someone said, "Hey, look, we know that you've been out for 5 years, and we want to let you know that, hey, look, if you're not registered to vote yet, you can register to vote." That could be kind of creepy and concerning that information is so available. So thank you.
Representative Harris.
Thank you, Mr. Acting Chair. Real quick, my buddy Representative Carter kept interrupting you, Ms. LeBlanc, and I think I got what you were saying, but you said two sides of the same coin. Can you just explain that real quick?
Sure. So under the current election code, there's essentially two types of reports we're required to provide the Secretary of State with. The first is any individual who is under our custody or supervision. So that would be roughly all 70,000 people, their names. Essentially, under the current law as it stands, without these new exceptions, those people are ineligible to vote because they're under an order of imprisonment. And I believe that's the list you used to determine the disqualification. Right. In 2018, Representative Carpenter added another reporting requirement, which is to provide the list of people who have completed, who are no longer under an order of imprisonment or under the custody of Department of Corrections. So that ends up being those who have completed and therefore, by definition, would be eligible to register. So if you're on list 1 that they get, you're disqualified. If you're on list 2, it means you're not part of DOC anymore, and therefore you're arguably eligible to register to vote. It really has no involvement with this new law dealing with the 5 years incarceration or anything like that.
Okay. So the way that you've outlined it today, Mr. Secretary, you are required by law to do it the way you're doing it today.
Absolutely.
Right. Because there was
no substantive amendments to those sections of the law, 3 sections of the law. The 171, which are the lists that are provided and certified to us by DOC. The second is the process by which, once we notify the registrar, then they notify the individual that they are suspended, and we call it a 21-day challenge. That during that 21-day period, that individual must appear to us with the appropriate documentation from the Department of Corrections.
Okay. And then my final question, because I know we've been here a while. Ms. LeBlanc, you said there's 36,500 that could be eligible to vote?
I think that's roughly the latest number I had, which would include probation and those on parole who have not been incarcerated in the last 5 years.
Well, I don't know if either of y'all at the table can answer this, but we were told in this committee on this bill as it passed out of this committee and off the floor that it only affected 4,000. Can someone tell me how this vast difference now that we've gone through this whole process, that it has grown from 4,000 to 36,500? And and the reason I'm asking this is we've gotten a lot of calls as representatives, when the paper came out and said it now makes 80,000 people eligible to vote. So I'm just wondering what the difference is. I don't know if...
I wasn't involved in any way in the committee testimony in this committee or the House floor. My understanding is there was a question about how many people on parole this would impact. No one really ever discussed the probation. And then again, the order of imprisonment as it defines what that includes is an election code term. So that if there's any confusion about the impact, the numbers were related specifically to those who were on parole. And
Right,
would
and I
have
heard those
certified.
questions asked about the everything that you just said, and the number stuck to 4,000. And I'm trying to figure out. I didn't vote for the bill on the floor, so I mean,
The
but-
4,000 specifically applies to those on parole. It's not if probation is included in this, it would be roughly 30,000 people on probation.
So, as a law was passed, probation is included, right? Is what you're saying?
I believe that's both of our agencies' understanding when looking at the definition of order of imprisonment and everything it entails for a felony conviction. If you have not been incarcerated pursuant to that probation, you would be essentially not lose your voting rights.
I think probably where some of it got lost in translation in the debate, just looking back, Representative Harris, is that no one ever really focused on what the definition of an order of imprisonment is in the election code. And so by not taking that into account in terms of the debate, it left it in a foggy place for everyone.
So now, if we were going to go back to the original intent of this law, which it was explained to this committee and on the floor to affect just parolees, then you would have to redefine that, have a new definition of
You'd have to adjust the act that was passed. The definition itself says an order of imprisonment means a sentence of confinement, whether or not suspended, whether or not the subject of the order has been placed on probation, with or without supervision, and whether or not the subject of the order has been paroled.
Right. Okay. Well, I just wanted to clear it up. You know, there's been a lot of articles about this, that, and the other. We're getting a lot of calls. So the number that this law affects right now, if every one of them did the procedure that you're talking about, would be 36,500 roughly. Okay.
Yes, sir.
Good. Thank you very much. Thank you.
Thank you, Representative Harris. And I just want to embarrass Ms. Laborde to recognize her mother, Claudia Laborde, who's here watching the proceedings, and her grandmother, Julie Barfield. So welcome to the House and Governmental Affairs. So they're making sure you're doing a great job.
Yeah, thank
So,
you.
but thank you.
Thank you.
Okay. You had a question? Okay.
She was
I'll
trying to
represent-
leave. She thought that was her exit.
Representative Ivy, back for another bite.
Yeah, thank you. Sorry, apologies. So just for clarification, Ms. Laborde, in
was looking at my
y'all's
weapon.
system, there's only two ways to code an individual, right? You mentioned the PR.
Right, to classify them as what type of custody they are under Department of Corrections.
Right, it's
They're
either
supervision
supervised
or
or-
prisoner.
Right.
PRI.
And so in relationship to, I think the line of questioning Representative Harris was getting at, as far as what was presented and what people were expecting, if you're providing the list, they're either going to be on one or the other, the PRIs or the supervised. And so if there's a distinguishing factor, between parole or, your probation, things like that you would need a third classification.
No, those two aren't related to each other. So when he was
Okay.
talking about the confusion as whether or not probation fell under this new exception in the law, it references or the exclusion is on if you're under an order of imprisonment, which is not a term that we use in corrections, or is it defined in the criminal code?
Okay.
It's an election code term for purposes of determining voter eligibility.
Okay.
So that was never discussed as to what falls under order of imprisonment.
Okay.
And whether or not that included probation.
Okay. Thank you very much.
All right, thank you, Representative Ivy. I have it's Ms. Lowry.
And maybe I might need Mr. Freeman back up here. I'm not sure. And this might just be another twist, but since y'all talked about perhaps the need to define the word incarceration and the need for legislation, and there was the question about incarceration for misdemeanor purposes, is it possible that a person who was convicted of a felony and is on probation or parole for that conviction, that the conviction of a misdemeanor violation might be a violation of that probation or parole circumstance, that then might
It could
re-trigger?
result in right, and if it resulted in a revocation, that would change the classification. If it doesn't result, that person would still be under supervision.
Okay. So it's just a matter
Correct.
of
The
if
impact of that
the
arrest
impact of the arrest and or conviction of a misdemeanor
on there.
might revoke their status on the felony conviction.
That's correct.
Okay.
But the mere sentence pursuant to the misdemeanor is not going to be considered as to being incarcerated pursuant to this felony conviction.
Correct.
Okay. All right. We don't have any more questions. So if y'all don't have anything else to add, we have a few cards from people who are present and would like to speak. And again, thank y'all. We have Chico Yancey from Vote. And then we also have Bruce Riley from Vote. So if y'all want to come on up. Welcome, Mr. Yancey and Mr. Raleigh, but welcome back. So,
Thank you, sir.
Good morning. Just please state your name and
My name is Chico Yancey. I'm with Vote, Director of Voters Organized to Educate. I am probably the elephant everybody's talking about in the room. I've been out of prison now going on 16 years, and I just want to get my voting rights. And I understand Mr. Harris about the numbers. The numbers are always going to be numbers. Every day somebody's going to roll out. When you sent me to prison and I did what I did and I was convicted, I've been out now, I pay my taxes, I do everything I'm supposed to do. I was punished, and that's what corrections is all about. And just think, we're talking about reform, so you're looking at the product that the prison system does work. So yeah, now I'm just trying to get my voting rights, and hopefully we could get as many people as we can to register to vote. And that's all this is about.
all right. Thank you, Mr. Yancey and Mr. Riley.
Thank you, Mr. Chair. My name is Bruce Riley. I'm also with Vote. Just wanted to add just a couple things, and and I really appreciate the conversation that we've had, and the secretary, and working with DOC to come up with a system that hopefully we can fine tune as we go along. So we have to start somewhere, and I respect that. But just a couple things that I think are important. Is that this form, which is very simple enough to show that people are eligible, the draft form, nowhere on it is any requirement for my signature or any of the other people. So it's really it's requiring the folks, and over the course of a year, it's far more than 36,000 people who become eligible and ineligible and eligible again to vote. It's requiring those folks just to be like errand boys and errand girls for 2 state agencies, for people to go to one space and then bring a physical piece of paper. And one would think that we're much further along as a digital society, although some have their doubts that we could fast track that quite a bit. And when someone gets voting rights, there's a issue about whether or not there's unnecessary burdens upon them to exercise that right. And the history of voting rights in this country has had times where that burden was deemed ultimately to be unconstitutional. We've had plenty of people who've had voting rights but not been able to exercise them in this country and in this state. And so I respect this body's intention to create a system that allows and encourages people to vote in the same way anyone else would be able to vote. The law that was passed last year was incredible, and I hope people can keep in mind, when not wanting it to apply to people on probation, keep in mind that probation is considered to be an alternative to incarceration. Probation is considered to be lesser than sending someone to prison. And so if it's that much lesser of a punishment, why would it include the loss of voting rights? And over the course of a month, a few thousand people are going through the probation system, coming on, going off. Right. And so if all those people are dealing with a lesser than incarceration kind of punishment, so why should the most basic right be something that's stripped of them when they're still allowed to go and live raise their children, work, and do all those other things. Thank you.
Thank you, Ms. Riley. Representative Harris.
Just real quick, Mr. Chico, right?
Yes, sir.
The law that passed, that we were told in committee and stuff, would have enabled you the right to vote, correct?
Yes, sir.
And this one does, provided you do everything else. And my next point is about the probation. I don't think there's any question today that we're even discussing that, whether they should vote or not. The reason I brought up the numbers is very simple, because everything that we heard, including the press report, said 2,200 to 3,500 would be impacted. And then in a certain interpretation of that law or something, enlarge that number. And the reason I asked the question was, that's my job as a legislator, to see what happened as a legislator, to make sure that we get all the facts when we're addressing something like this, especially of something of this nature that's been being tried. I've seen you in this committee and at the Capitol all 7 of my years, I think, that I've been here. So,
Try to come,
right.
To show that I'm a citizen doing the right thing.
Exactly.
I want to be involved.
Right. So when we ask about these numbers, it doesn't mean that
Right.
anything like, I understand your concerns,
Well,
but
Rep. Harris, with all respect, I when we first presented this bill, and I sat right next to Representative Smith, and I explained what I thought was very clear about who would be impacted by these laws. And we can watch the game tape. It's there. And I explained that there's 2 categories of people.
and that's why, why we're looking
so
at
if,
it.
you know, if the media or someone else ran with it, or if the topic honed in on parole, I mean, that I'm not the governor, I'm not a legislator, I couldn't control.
But you're a lawyer now, right?
Well, you know, but I couldn't control that dialogue, and I actually kept on hammering on the media, and
Right.
those new articles came out because I kept pushing back on the media, saying you're not clearly explaining this.
Right.
And finally, it took hold, and I'm glad that we got to that point where these articles were coming.
Well, it's going to take some legislation to do what Representative Ivy was talking about, what you're talking about, one shot, because the law is the law, and the Secretary of State's following it to the letter. Because I know I've been involved in some of these conversations too, and that'll be coming back up as we go forward. But I appreciate y'all being here, and I appreciate the work the Secretary of State has done working through this process after all of the articles and the first stuff that came out. So,
May I make one comment? If we get to 30,000 or whatever the number is, 2,000, just remember, that's across the state of Louisiana. In your district, it might not be affecting maybe 10 people.
oh no, I might have a lot of relatives that might be affected. You never know. So,
And that's a lot of information, too much information. But the thing about it is, I want people to understand, if you're talking about, even if you say there is 36,000, that's across the state of Louisiana in 64 parishes.
absolutely.
Out of that number, we're trying to hope we can get 50% of those people to register, because we're trying to make it easy, so we don't want to frighten anybody. And I'm sure the media, there's all kinds of numbers out there, fake news or whatever. But just remember that people are trying to get their lives on and becoming a part of the system. I just sent my income tax out, so and paid my things. I'm a citizen now. I just want to have the right to vote. That's all.
Well, you have it now, it seems, with this law, and if you go through the procedures that the Secretary of State has put in place, and I think that's what the law was meant to do. So, but thank y'all for being here today. Thank you, Secretary of State. I think you've done a fine job working through this.
Thank you, Representative Harris. Representative Jenkins.
Thank you, Mr. Chairman. Mr. Yancey, I know your organization Vote got boots on the ground.
Yes, sir.
Are you aware if anyone is experiencing problems presenting information to local registrar of voters, their letters or information that they're trying to take in to become eligible? Is there any information you can give us on
I've
that?
experienced it personally. Probation, parole, and DOC has done everything they humanly possibly can to help. They gave me a letter and said that I've been out and I'm up to date and I'm eligible when I went to the registrar's office. So I left probation, went to the registrar's office. and the register looked at me strange. I don't know nothing about it. So now I got to go back, and now I said we're getting a form together, and I think that's what Representative Carter, Representative Ivey, and everybody's trying to do, simplify this matter. So the day we come, and the secretary now, and DOC, and everybody look like they're trying to work together. I understand that. And they now got this new form. So now we got to go out and try to get the information out to the men and women that may be affected by this. And guess what happens? Sometimes they, guess what? That's just another stumbling block, and I don't want to mess with it. We want people to register. So we thank you today for what you're trying to do to simplify this matter. Because the Secretary of State, he's only got to follow the law. I understand that. So now it look like we're going to have something. So now we got to start all over again to let the public know that may be eligible for this. Now you got to get this. Hopefully, this will encourage people to register to vote. Does that make sense to everybody here? So yeah, there's been a stumbling block because I've had the letter and this stumbling block, and then now we're going to get another letter. So I appreciate what everybody's doing, probation and parole, the DOC. I appreciate what everybody's trying to do. Thank this committee for trying to help us.
And thank you all for going into the community and making sure people know what we're doing here. Everybody can't come down to the Capitol and know these things, but I think it's been a very meaningful discussion today. And some things have come out of this where maybe we could tweak some of the procedural aspects of what we're trying to do. And everybody, like you say, work together and not against one another. And I think we see some improvements down the line. Thank you, Mr. Chairman.
Thank you, Representative Jenkins. Representative Ivey.
All right. Thank you, Mr. Chair. A couple questions for you, Mr. Yancey. First, I'm a big advocate of people going to vote, but I also respect the individuals who decide they don't want to vote or even don't even want to register to vote.
Yes, sir.
In Louisiana, and I think nationally, we have a problem where people who are registered to vote don't even make the effort. And look, I've personally, if you can go look at my record when I was younger, and different things. Look, I've missed votes when I was younger. And so all that said, people have the right to vote or not to vote. And so we certainly want to respect that right. And so these individuals who formerly incarcerated fall into this category, and they have the right to go and register to vote. I think it's presumptuous of us to assume that they all want to go register to vote.
That's true.
Okay, they may be mad against the government for. I mean, don't believe in the system. I mean, there's plenty of individuals who feel that it's rigged and different things, different elections, and so I don't want to presume that they want. And so, with regard to, and I'm assuming, do you believe in the individual's right to privacy when they are released and they're no longer part of the the system, being incarcerated? Do they have the right for their information that they could fall into this category to not be publicly released?
And we're not asking for anybody's information.
Well, I mean, just their name on a list would be, but even their name on a list as falling under this category being made public, that may be something that someone would not want out there.
And I don't see anywhere we're going to get anything publicly that we're going to know their name.
Well, I know. I think Representative Carter was alluding to, trying to gain access to such a list so advocacy groups or, people who can go seek these individuals out and inform them and try to get them to register to vote. And so, I mean, it's well-intentioned, obviously, but I believe it may encroach upon that individual's right to privacy. Well, and so have y'all contemplated this process?
I mean, Secretary of State or some others could do a little data crunching. It probably wouldn't take that much time to even just to get a snapshot of how many people are already in the van, the registered voters list, right? Because we know that some people, and I'll just use Chico as an example, were a registered voter, and then as we hear after so long, they send out the letter and you're no longer there or whatever, and you get purged from the rolls, right? And so there's some folks that are going to be purged from the rolls, but they were voters. And then there's other people who are going to, maybe they are registered voters, they're voting all the time, they catch a probation, or they did motor voter and they registered. Maybe they didn't vote like you did as a younger person, right? But
I didn't vote as often, but yes,
okay,
yeah, I did vote.
But they were registered, and we know that younger people don't vote as often, right? And we also know that the criminal justice system impacts younger people more so because people are in a different space in life and can make rash, impulsive decisions. And so there's people who are already registered who have signed up, so to speak, have chosen, but they're also already on other lists of the DOC. They're seeing their PO on the regular.
But that's a list that's made public. If someone's registered to vote, correct? You can.
Right. So
yes.
So the thing is, they'll already.
But they've already made that election.
Right. And so the thing is, what we may end up finding is a lot of people already are, at least in turn, not necessarily public. Go to the grocery store and there's the list, right? But
it's available.
But the people who are trying to knock on doors, as Rep. Carter was talking about, those people are going to be in databases already.
Right, but connecting the dot between you're a former convicted felon, right, and you fall into this category and connecting that dot, I believe, is the privacy concern. That maybe they don't want everybody who comes knocking on their door. When we get our walk lists and things like that, we get all the demographics. Should we have a former convicted felon eligible to vote now under this new law? Should that be a box? I don't believe it should. And so again,
well, I'll speak for myself. I would rather have someone knock on my door and encourage me to do something that's positive in my community than go and have a landlord say, yeah, I did a background check and you can't live here, or have an employer say, I did a background check and I don't want you working here. Those lists are out there as well. People do background checks all the time, with or without your permission, and use it in a negative way. This is using that same information in a positive way. And so I would much rather we do that than what's already happening is these types of lists are being used for blanket discrimination. We were here a couple years ago about an education bill that we were trying to encourage people to have opportunities to seek higher education. And that passed, and everyone saw that as a good thing. So here we are trying to encourage people to vote, and that passed, and now we're trying to tweak that. So I think there's a big difference between using such information in a positive way or using it in a way.
Well, you assume that it's a positive way for an individual.
Well, I would hope that all members of the legislature would see voting as a positive thing.
No. I'm not talking about myself. I'm talking about the individual who may be incarcerated and don't want anyone to contact him about voting. You see what I'm saying? We assume that it's positive, but everyone has different perspectives on that. So next, to me, the purpose of the law itself is to be indifferent, right? We facilitate, eligibility, and we are indifferent as far as the law goes, whether or not it's their right to register or not. Now, the Secretary of State does a marvelous job of promoting elections, and it's, I think we were the first state to have an app with all the, and so it really remarkable and a model of how to get the information on what's on the ballot and register vote. It's phenomenal. And it sounds like they've already, it's in the works to everywhere where these public notices have to be, even including at the OMV, which again is going to be very convenient for people who aren't aware to become aware, and so to me, that's all. Those are the mechanisms that we have in place for everybody else, right? And we're adding this provision to the same mechanism that everyone else has. So for that purpose, I don't believe there should be any special exception, as far as from a state promoted effort to reach out and let these people, other than some normal notification, maybe DOC could send out a letter after 5 years. Hey, look, we're tracking this. Just wanted to let you know. That would not be unreasonable. But to have some major effort to go out and try to find everybody, I don't think that's how, the system should work. But again, you know where I stand. I offered an alternative option for the felony voting. Mine was a little more restrictive. I felt it was a good second base, compared to the, what I think y'all felt was more of a home run. And so, again, you know where I stand on, I believe, anybody who again, I had a 40-hour community service requirement in mind, but there are people who really want to be who are civically minded and want to exercise that. And so I am glad that that the issue's been brought up, and again, there's some debate on some of the other like some of the concerns Representative Harris has brought up and others that I've heard, and so we'll see what happens this next session with possible tweaks. But anyway, it's all in all, it's definitely good to have this mechanism, and we just need to get it fine-tuned. With regard to technology, I did a HCR study commission on the technology needs. We don't invest in our transportation infrastructure in Louisiana or our technology infrastructure. So DOC, OMV, there's massive needs. And so it's not actually as simple as you would think to connect some of these dots. The systems are, we have OMV who's running off of a mainframe and Cobalt.
Representative Ivey,
So anyway, I apologize. I just wanted to express the actual legitimate difficulty
and that's
in
all a
connecting these dots.
discussion for another
Thank
day.
you.
But thank you. All right. Mr. Riley, Mr. Yancey, anything else? Thank you all very much for being
Thank
here.
you for listening.
All right.
Thank you.
And that's all we have on that. If Secretary Ardoin would like to come up to the table, if any closing comments on Act 636.
I think we said it all.
All right.
But thank you very much for having this dialogue. I think, obviously, we've been hard at work at trying to make the date of March 1st. I think we're there. I look forward to the conversations, more conversations with the registrars. We pulled a small group of them in when we were first considering the farm, so there was significant input there and with their legal counsel. So I just want to thank all the parties involved coming together. I've had tremendous number of calls from legislators discussing the issue, trying to work out the idiosyncrasies of the law and where the law is tremendously lacking. And so I think we've defined those areas that we need addressing in order for clarification to move forward on this.
All right. Well, thank you all, and thank the department, probation and parole, and everybody for getting this process going. So
Thank you, sir.
All right. Thank you.